Oh man, legal cases are so much fun, aren't they? No, wait. What's the opposite of fun? That one. I don't remember if we've talked about Entrepreneur v. Meta, but this is one of those where they try to, like the Ziff Davis cases dragging on the coattails of the OpenAI cases. This is grabbing the coattails of Kadrey v. Meta. And I wasn't going to cover this because there's nothing there. This is totally nothing. But we do have over in Kadrey v. Meta, the plaintiffs are trying to amend their complaint for a fourth time. And the reason why is this entrepreneur case. So the Kadrey plaintiffs are grabbing on the coattails of the people who grabbed on their coattails. You see how this works? Because they have no arguments, everything else is done for. So as we've seen in so many other AI cases, the only thing they can do is copy off everyone else's homework and try to see if they can make it stick. So we're just going to kind of glance over this filing in Entrepreneur v. Meta, just enough so we understand what we're talking about when I give you the update in Kadrey, which is a big one. It's basically, I think, the OG AI case. I think it's even older than Bartz v. Anthropic. I think Kadrey started first. So this is Meta saying that Entrepreneur's claim should be dismissed. And since they've totally lost on what these cases are supposed to be about, which is, oh my God, AI is based on theft, they've all lost on that, so they're trying on everything else, where they fail to even allege or even state a claim. So in Meta's motion to dismiss, they say, in Kadrey v. Meta, the other one, this one's Entrepreneur, remember, the court granted summary judgment to Meta on the basis of fair use because Meta's use of the works was highly transformative, remember that? And plaintiffs presented no meaningful evidence on market dilution at all regarding fair use factor 4. Yes, they are losers! And that's why they ended up having to add in all this stuff about seeding, which has nothing to do with any of the AI stuff. So if you remember us covering that, now Plaintiff Entrepreneur Media hopes it can establish the factor 4 market harm that the Kadrey plaintiffs failed to demonstrate. Whether plaintiff is able to overcome the fair use defense, we'll figure that out after discovery. This motion is about plaintiffs' meritless ancillary theories, contributory infringement, and violation of the CMI stuff. Yes, we're seeing that yet again. It's failed so many other times, but they're going to try it again. These theories are legally unsustainable based on the facts pled, and thus should be dismissed with prejudice at the outset. So according to plaintiff, Meta aided the infringement of those works by third parties who downloaded the works. But the complaint does not identify any completed act of third-party direct infringement. It also fails to plausibly allege that Meta knew of such an act or materially contributed to or induced infringement by others. They can't even point to anyone else who infringed. Like, oh yeah, they live in Niagara Falls. You wouldn't know them. No, but trust me, they exist. That's basically what they're saying. Plaintiff contends that Meta removed CMI. Yeah, we know how this works. But plaintiff provides no basis for the court to infer that removing CMI from training data causes concealment, let alone that Meta knew or had reason to know that CMI removal could have that effect. Second, plaintiff contends that Meta distributed CMI-less versions of plaintiff's works. So they took out the CMI and then they distributed them. But this makes no sense! Meta could not have seeded datasets without CMI at the same time it was allegedly acquiring those same datasets with CMI intact. Because when you seed back exactly what you've downloaded. And in fact, the system enforces that. Because these things are hashed all the way through. The whole thing is hashed, each file is hashed, the pieces are hashed. And so you're not going to be able to seed back a file if you've changed it because the hash is not going to match. You can only seed what you download, and that's on purpose. Because you want to seed what was originally shared, not what someone else might have modified, and haha, I'll stick my virus in here. Because you're downloading it from all these third parties, you need to trust them. And since you can't actually trust them, the hash is how you trust them. Since the hashes match, you know you're getting the original file, not a modified one. So it's impossible for Meta to have seeded back a modified file without the CMI. That's ridiculous. That's insane. First, the complaint does not plausibly allege any act of direct infringement by a third party. Second, even if the complaint did adequately allege direct infringement, it separately fails to allege that Meta had knowledge of the infringement. Finally, the complaint contains no allegations that Meta materially contributed to or induced such infringing activity. Each deficiency is independently fatal to plaintiff's claim for contributory infringement. The complaint fails to identify a single third party who downloaded any entrepreneur work from Meta, any specific entrepreneur work that Meta allegedly uploaded, any completed infringing download traceable to Meta's alleged seeding, any instance in which Meta's conduct caused or enabled a third party to infringe, or whether and how a third party supposedly infringed entrepreneurs' copyrights. But other than that, moreover, it is irrefutable that plaintiff's list is a minuscule portion of the hundreds of terabytes of data that Meta allegedly downloaded. The bare allegation that downloading by torrent necessarily involves some uploading, which we've talked about repeatedly in our previous coverage, check that out, does not amount to a plausible allegation that Meta uploaded any part of any plaintiff's alleged infringing works. Nor does it amount to a plausible allegation that any specific third party downloaded a substantial portion of any of those works from Meta and used those works in a way that would constitute copyright infringement. There's a lot of steps to that. They can't even make any of them. The plaintiffs must plead specific acts of infringement. Here, plaintiff pleads none. Its theory rests solely on the assumption that the infringement must have occurred because torrenting systems can involve some uploading. But allegations concerning what unidentified third parties might or can do are not a substitute for pleading actual infringement by those third parties. And remember, we covered everything Meta did to make sure it wasn't seeding anything. Plaintiffs piggybacking on implausible theories from Kadrey and the unnecessary fact and expert discovery it would invite should not be indulged, particularly given that plaintiff has made no allegations in its complaint explaining how CMI removal allegedly caused concealment of Meta's alleged infringement. Plaintiff's theory assumes that removal of certain CMI is the difference between a model memorizing identifying information about training data contents or not. And, but for Meta's removal of copyright notices, plaintiff would somehow be able to determine from Llama's outputs that plaintiff's works were used as training data, when, as would really happen, it would just be hallucinating CMI, fake CMI, just because it knows that that kind of goes along with those things. But plaintiff offers no allegations about how Llama outputs would be meaningfully different had CMI been left intact. But even ignoring plaintiff's self-serving selective invocation of the Kadrey record, plaintiff's failure to plausibly articulate a causal relationship between CMI removal and concealment forecloses any inference that Meta knew or had reason to know that such a relationship exists. In the absence of a plausible theory of concealment via removal of CMI, culpable scienter cannot be inferred, just like we've seen in all the other cases where they've tried this. Plaintiff relies on conclusory allegations and abstract descriptions of how peer-to-peer file sharing works in an attempt to plead contributory infringement because there are no plausible or concrete allegations of any third party infringing any of plaintiff's 71 purportedly infringed works, let alone of Meta's knowledge of such an act or conduct by Meta that supposedly materially contributed to or induced the act. As to the DMCA claim, plaintiff's theories suffer from baseless, inferential leaps and logical fallacies that, in some instances, are contradicted by the public record in the Kadrey litigation upon which this claim is premised. That's going to make a difference to the one we're about to read, the one I really wanted to cover here. Those defects cannot be remedied through amendment. Accordingly, because amendment would be futile, these claims should be dismissed with prejudice. Alright, now that we've done that, let's go over to Kadrey and see what these loser plaintiffs have to say for themselves. What they want to do is a fourth amended consolidated complaint. They just want to keep going with this. plaintiff's latest motion for leave to amend, transparently prompted by Entrepreneur Media's assertion of a contributory infringement claim, should be denied because the new proposed amendments are unduly delayed, would prejudice Meta by further disrupting the case schedule, and expanding discovery yet again to address the new claims, and are futile. Critically, all of plaintiffs' proposed amendments could have been, but were not, offered as part of their November 27, 2024 motion for leave to file a third amended consolidated complaint. So they've already changed it 3 times, and the court granted on January 13, that was a year ago, and pursuant to which the parties have proceeded towards completion of discovery over the past year. These loser plaintiffs are wrong that their amendment will not require more discovery and will not disrupt the case schedule. First, Meta will need to conduct discovery into the new allegations of third-party infringement and Meta's supposed material support thereof, and further discovery of the additional so-called loan-out corporate plaintiffs. Then, to the extent plaintiffs' claims survive summary judgment and the court permits class discovery, further expansive discovery will be needed to address a putative class that extends far beyond the scope of the plaintiff's infringement claims. Plaintiffs also seek to add a piracy expert in light of their proposed amendment, and Meta would thus need to retain a new opposing expert, which would be difficult to accomplish on the present schedule. See, this is exactly what you shouldn't be allowed to do. Just keep pushing it out, keep amending, keep delaying, amending and amending, pushing back the process year after year after year, making it difficult for them to do business, raising their legal costs. That's when you know the process is the punishment. That's when you know they aren't acting in good faith. I mean, this is exactly what we saw the Sandy Hook plaintiffs do with Remington, a case that should never have been let in the door, a case that is totally exempted by federal law. They just kept pushing it and pushing it and pushing it and pushing it and pushing it until they drove Remington into bankruptcy. This is exactly what should never be allowed. Just a month ago, loser plaintiffs represented to this court that the parties anticipate that after the summary judgment phase concludes, there will be class-related discovery to provide an adequate record for the consideration of class certification. There is no good reason to deviate from that sequencing now, particularly given that, as the court recently observed, plaintiffs have lost on their core training claim because they are losers and now press only an uncertain distribution claim, making certification in this case highly unlikely. Moreover, these losers' new proposed class definitions extends far beyond the claims that the losers brought in this case, books used to train Meta's llama models, to include any book, article, journal, or other written work that was reproduced in connection with any Meta LLM. Such a significant expansion at this stage of the case will require substantial additional discovery. Plaintiffs' notion that class discovery can be quickly completed is based on unfounded assumptions and is wrong, and there is simply no need for it to occur now. Nearly a year before the entrepreneur complaint apparently inspired the new proposed contributory infringement claim in Kadrey, loser plaintiffs specifically discussed this same theory with the court in the context of the TAC, arguing that it was, oh my God, look at this, not copyright infringement to, when you're torrenting, knowingly use your own computer hardware and other bandwidth resources to participate in the illegal peer-to-peer file sharing networks of pirated data. That's not copyright infringement. That's the plaintiff saying that. That's the copyright holders saying that that is not copyright infringement. It was only after Entrepreneur pled a contributory infringement claim in November 2025 that plaintiffs did an about-face and attempted to add such a claim here. This effort comes far too late. They don't actually have a complaint, they're just copying off each other's homework. Loser plaintiffs claim that the only additional discovery they would need would be an additional expert. As the court is aware, plaintiffs have not abided by their prior commitments to seek no new discovery after obtaining leave to file the TAC, and continue to seek yet more new discovery to this day. After what has it been, 4 years? Plaintiffs do not explain what this piracy expert might testify to beyond a vague assertion about an unspecified full scope of harm allegedly caused by Meta's torrenting activities. In all likelihood, this piracy expert would offer theories regarding torrenting that could have and should have been in plaintiffs' expert reports a year ago. We've already been through all this expert stuff. Their experts talked about BitTorrent. Our experts talked about BitTorrent and debunked everything they said about it. We've been through this. They could have done it then. They should have, and they didn't. While it is unclear how plaintiff's piracy expert would be relevant to any of the loser plaintiff's claims, Meta would likely need to offer its own expert in response, and depending on what the loser's new expert asserts, Meta may need more discovery to rebut it. Meta must also be permitted to probe the factual basis of plaintiff's contributory infringement claims through discovery, including additional written discovery, contingent interrogatories, and possibly third-party discovery about the supposed benefits and support that were allegedly provided to so-called shadow libraries. As Meta has previously explained, the tax class definition is overbroad and unwarranted because it seeks to expand the case beyond conduct related to Meta's llama models, the subject of all of the complaints in this case, including the TAC, to any LLM training research or development at Meta. The FAQ's proposed class definition seeks to broaden the class definition even further by decoupling torrented works from whether they were reproduced in connection with Meta's LLMs. All legal or beneficial owners of any book, article, journal, or other written work that Meta uploaded, offered, or otherwise made accessible to others and or downloaded via BitTorrent or otherwise reproduced in connection with its LLMs before being uploaded, offered, or made accessible to third parties and or downloaded or otherwise copied by Meta or within 3 months of first publication. Oh my God, that's long. Wow. They're making the broad side of a barn that they can shoot arrows at and then draw bullseyes around. Indeed, as written, the class definition does not even require that the works have been torrented, the only remaining claims in suit. Everything else is gone, just the torrenting is left. It purports to sweep into its ambit any work that Meta ever uploaded or offered or made accessible or reproduced or downloaded via BitTorrent in connection with any of its LLMs. Footnote. You want to see how broad this is? They explain how broad this is. As an example of the dramatic overbreadth, if Meta bought a physical copy of a book at a bookstore to support its LLM development efforts and then offered to donate it to a public library, it would fall within this proposed class definition, even though that conduct has nothing to do with the issues remaining in this case. You buy a physical book, you do your AI stuff with it. Now what do we do with the book? Donate it to a library? Infringement. Sell it to a used bookstore? Infringement. You got a friend? Say, hey friend, I'm done with this book. You want it? Infringement. That's how broad this is. That's how desperate they're getting. So the court should stay Kadrey while Entrepreneur proceeds through discovery. Such a stay would maximize efficiency in both Kadrey and Entrepreneur because Entrepreneur can seek streamlined additional discovery. It avoids the potential for serial expert discovery, and it minimizes any potential inefficiencies for the parties and the court that may arise if expert discovery and summary judgment are addressed in Kadrey before Entrepreneur even completes discovery on the same conduct. So just stop what you're doing. You've had plenty of chances to amend it. You've said what you had to say. Let's see what happens in Entrepreneur, and then let's get these cases done. Justice does not require permitting loser plaintiffs to amend for a fourth time. To the contrary, it requires denial of that request. Nor should class discovery or certification briefing be permitted at the juncture. Rather, the court should stay this matter pending completion of discovery in Entrepreneur. Oh, the crazy things we have seen. Hey, BitTorrenting is not copyright infringement. Did you know that? That's what they had said before. Because it was convenient for them to say it before. You know, that's really what makes me want to have video or audio of all of these, or at least a transcript, because that was one of the things that they said in one of those hearings. How many more juicy tidbits like that are there in the transcript where they admit that it's not copyright infringement. Exactly what we've all been harassed with for over 25 years is not copyright infringement. That'd be kind of nice to see. As it is, you see how desperate they're getting. You see how all these loser cases, the loser content cartels keep pushing forward, just get more and more desperate. They just keep moving the goalposts all over the place. Hey, it's the outputs. No, it's the model. No, it's the training. No, it's the downloading. And now they want to change it for a fourth time. That would be 5 overall, because that would be the 4th amended complaint. There's also the original unamended complaint. So they've already had 4. The 3rd amended complaint is the 4th one. And they want to do a 5th one. Yeah. If you're still on the side of the big content cartels, comment below and let me know why. How can you possibly still be on their side at this point? How can you possibly think that they have any validity in this whatsoever? I want to know. Thank you so very much for watching. Comments for the comment god, shares for the share throne. Please hit like, subscribe, and the bell. And of course, donate Doppelgosity.tv keeps me doing what I do. Through thick and thin, through all the problems. Yes, thanks for all of the well wishes. For those of you who don't know, we lost our best friend, a 17-year-old Chihuahua. We'd had him since 2011. He was a rescue. I'm telling you, you will never know love like the love you get from a rescue pup. So we lost him on Saturday. It's Thursday as I record this, and so I'm just starting to get back into the swing of things after that. So thank you for understanding about this little hiatus, and thank you so very much for watching. Until next time, stay strong and be free.